Assignment. Assignment is when one party passes responsibility onto another. Surrender. Surrender is giving up possession of a property. Constructive eviction. Constructive eviction is when a landlord does something or fails to do something that he or she is legally obligated to do, rendering the property uninhabitable. For example, making sure the water doesn't work or making sure there's no heating when it's freezing outside. Estoppel statement. An estoppel statement is a signed statement certifying that certain facts are correct, which cannot be later contradicted by the signer. For example, that a lease exists or that rent is paid to a certain date. Deed. A deed is evidence of property transfer, as opposed to title, which shows ownership. Think of a deed as like a receipt when you buy something from the store. It shows that something was purchased and ownership transferred from one party to another. Grant deed. A grant deed is a deed that includes two implied warranties. One, the grantor has not already given the title to another person. And two, the estate has no undisclosed encumbrances. Remember, an encumbrances is something that limits title. Could be anything from an easement to unpaid taxes or a mechanic's lien, things of that nature. It is not necessary to record the deed. Grant deeds are considered officially executed when signed by the grantor. Quitclaim deed. A quitclaim deed is a deed that operates as a release. It transfers property quickly, but without any warranties on the title of any kind. Quitclaim deeds are typically used when you want to transfer ownership, from example, a father to a son or very close friends. That's why typically when a quitclaim deed is used, money is not exchanged. Warranty deed. A warranty deed is a deed in which a property owner then transfers the title, warrants that he owns the property free and clear of all liens. Liens, if you remember correctly, means that you owe money. So it's saying no money is owed regarding this property. Special warranty deed. A special warranty deed is a deed in which the grantor warrants only against defects that occurred during their ownership. The grantor of a special warranty deed does not provide any warranty or guarantee against any defects in clear title that existed before they owned it. General warranty deed. A general warranty deed is a type of deed where the grantor or the seller guarantees that he or she holds clear title to a piece of real estate and has a right to sell it. The guarantee is not limited to the time the grantor owned the property. It extends back to the property's origins, which is very different than what we just learned about a special warranty deed. Bargain and sale deed. A bargain and sale deed is a deed that conveys real property without covenants. The grantor is implied to hold title and possession, but there is no warranty against encumbrances. Reconveyance deed. A reconveyance deed is a deed which indicates that the borrower is released from a mortgage debt and transfers the property title from the lender or beneficiary to the borrower. Most commonly issued when a mortgage has been paid in full. So in essence, when you pay off your loan, you could receive a reconveyance deed, which will be evidence that everything's paid off and you don't owe anybody anything. Title. Title shows ownership of the bundle of rights of property. Basically says that it is yours. We learned a deed is evidence of a transfer. Title is ownership. Chain of title. A chain of title is a record of all previous owners of a particular parcel of land. It is important when deciding to issue the title insurance to know who owned it previously. Abstract of title. An abstract of title is a summary that provides details of the title deeds and documents that prove an owner's right to dispose of the land, together with any encumbrances that relate to the property. Cloud on title. A cloud on title shows defects in the title. For example, an unreleased lien or encumbrances that may invalidate or impair a title. Another example of a cloud on title, if, for example, a single woman gets married. She may get married under her maiden name, but then when she tries to sell it, she's trying to sell under a married name. That could create a cloud on title, as it shows a complication there because the person selling it is not necessarily the same as the person who originally bought it. But it's easily fixed. But still, it's a cloud on title. Quiet title action. A quiet title action is a court action to remove a cloud on title or another claim that has been placed on title to property, thus quieting any challenges or claims to the title. Alienation of title. Alienation of title is a loss of title. It's the opposite of acquisition. Title insurance. Title insurance insures against any losses due to defects or problems with the title after it has been searched or examined. It ensures that the buyer is getting a clean title. However, remember, no title policy covers everything. For example, no policy is going to cover zoning. Standard policy of title insurance. A standard policy of title insurance is an insurance policy most buyers get to protect themselves from forgery in the chain of title or defective delivery of a deed. A standard policy does not cover a site inspection or a survey. Extended policy of title insurance. The extended policy of title insurance is an insurance policy with increased coverage. It helps with the dispute over property lines which are disclosed by a survey, and it covers improvements on an adjoining land. Estate and severalty. An estate and severalty is property owned by just one individual or corporation. Concurrent estate. A concurrent estate, as opposed to an estate and severalty, is property owned by more than one person. Joint tenancy. Joint tenancy is a type of concurrent ownership with unities of time, title, interest, and possession. You can remember that with the acronym TTIP. Joint tenancy has the right of survivorship, meaning if one joint tenant dies, the surviving joint tenants take the remaining interest. So therefore, if Bob has the property with Bill as joint tenants, and Bob dies, Bill gets the property. Bob can't will it to his heirs. And for that same reason, you wouldn't take joint tenancy with a corporation because corporations don't die. So the right of survivorship theory would not really work well with a corporation. Tenancy in common. Tenancy in common is concurrent ownership with unity of possession only. It does not have the other unities that a joint tenancy has. There is no automatic right of survivorship, so therefore you could will to your heirs. So go with my previous example. If Bob took a property with Bill, but this time it's tenancy in common, and Bob died, Bob's heirs could get the property because Bill wouldn't have the right of survivorship. And thus, a tenant in common would be a much more appropriate relationship if you were taking the property with a corporation. Encumbrances. Encumbrances is a burden on the property. It is a claim, lien, charge, or liability attached to real property. Title can still be transferred. Easement. Easement is the right to use or enter someone else's land for special purposes within limits. Land with an easement on it is encumbered. Dominant tenement. A dominant tenement is the land enjoying the easement. They could terminate an easement by recording a quitclaim deed. Servient tenement. The servient tenement is the land burdened by the easement, and more often than not, the servient tenement is much larger than the dominant tenement. Easement by prescription. An easement by prescription is an easement granted after someone has used or entered the land for a period of time that is given a legal right to continue to do so.